Good afternoon, everyone. Welcome to our webinar. I'm Ann Massey Badmus, and I want to thank you for joining us today. I'm going to give it just about another minute or so to let more people come in. I see some people coming in now, so let me get just one more minute and we'll get started. Thank you. Okay, let's go ahead and get started. Um, as I mentioned earlier, welcome again to our webinar, The Road to a Green Card, Mastering the PERM Labor Certification Process. I'm Ann Massey Badmus with Badmus Associates. For those of you who have not met with us, we are a law firm focused on business and family immigration for over 30 years. And we've worked with many clients regarding different types of green card applications, and in particular, the PERM labor certification application. So let's go ahead and get started. And I do ask you to excuse me a little bit. I'll keep my voice up. I am a little bit under the weather, or recovering from a cold. So my voice may go in and out, but I will try to keep that up as much as possible. Okay. So before we get started again, I do want to ensure that you all know that this webinar is really information being provided to you in a general manner. And of course, in the time that we have, we cannot cover all types of situations. So please take this as generally information and not legal advice for your specific situation. We do recommend that if you are interested in this type of process or any other immigration process, you should always reach out to an immigration attorney to advise you appropriately for your specific circumstances. Also, just a little bit of housekeeping. We do encourage you to ask questions. We will have time at the end of the presentation to ask questions. So to do that, please use the chat feature of Zoom. And so put in your questions at any time as we go along. If questions come up, feel free to add those questions to the chat and we will review them or answer them at the end of the presentation. We do ask that for confidentiality, since this is a forum where others are viewing as well, so it's pretty much sort of a public forum. Please make sure you ask your questions in a general manner. Do not provide personal details because we do want to maintain your confidentiality throughout this process. Okay, so today we have quite a bit of information to cover. So I want to kind of give you an outline of what we will be talking about today. We'll first of all talk about generally what is PERM, who is it for, and the three ways that applicants or employers and their employees can apply for PERM. We'll start out with talking about Schedule A. Pre-certified occupations. We'll talk about special recruitment, which is specifically for those who are teachers at universities and colleges. Then we'll talk mainly about the standard PERM recruitment process, which pretty much applies to everyone else who is interested in this process. We'll also review filing and how to file and what the Department of Labor does in reviewing the application. And then, of course, we'll talk about what the employee, as an employee being sponsored for your green card through PERM, what you should know about and what you can and cannot do or can and cannot control. We'll also talk about the what could happen if there is denial, or what is the risk of denial for these applications and how you can potentially prevent it. And then, of course, we'll have questions at the end for you to ask regarding this process. So let's talk about the foundation. What is PERM and who is it for, and what are the pathways? So PERM is a process that has pretty much been around for a very long time, at least since I've been practicing for over 30 years. And what it is intended for is to really pretty much protect the labor market of the US by ensuring that any foreign-born employee who is working in the labor market and who is being sponsored by an employer to get permanent status, that there is no negative impact on the US workforce, meaning that US workers are given the first opportunity, or the opportunity to apply for those positions that an employer is providing. So before a foreign national can receive a permanent labor certification through the Department of Labor, the US employer, who is the actual applicant at this stage, must prove to the Department of Labor that there is no qualified, available, and willing US worker for the offered position, the job that they're offering to the foreign national. There is no US worker available, and US worker meaning someone who is a US citizen or a permanent resident or even an asylee. So, and then of course, the other part of that is that there is a wage requirement, so that the employer has to agree to pay at minimum what the government considers to be the prevailing wage, or the wage that is typical for workers in the US. So the first step of the process is that the first step of the PERM process is the PERM itself. So PERM process is step one of the green card application. And so with that, the PERM is filed through the Department of Labor. Then after the Department of Labor has certified the PERM application, meaning that it has certified and agreed and approved that the labor market does not have sufficient US workers for the position that is being offered. So once that certification comes through from the Department of Labor, the next step is the I-140 petition, which is also supported and filed by the employer, and filed with the Department of Homeland Security USCIS agency. So that also is that is the second step. And then the final step is actually either the I-485 adjustment of status or consular process. And this is the individual employee applicant's application. So at that point, where we're at the third step, pretty much the employer has done its part through 1 and 2, and really does not have any much requirements in terms of the adjustment of status or consular process. So I do want to touch a little bit on this third step, although we don't have time to go through it in depth. But the third step is pretty critical to be determined, and at the time of the PERM application being started, it's important to also think about what that third step, or what option of the third step that the employee will choose. In some cases, there is no choice but for the employee to do consular processing. Maybe, for example, they are not in the United States or cannot maintain legal status in the United States. So there may be no other choice but then to do consular processing. However, most people who are currently in the US in legal status usually opt for the I-485 adjustment of status. That has been pretty routine throughout many, many years. But as some of you who are on the call, on the presentation, or on the Zoom today may have heard of a recent memo from the Department of Homeland Security, USCIS, discussing how they consider adjustment of status to be an extraordinary option, even though it is legally still an option. And so there may be additional requirements for someone to be able to successfully apply for their green card through the adjustment of status process. So that will be for another webinar. We will actually talk more about that next month in our webinar, because by that time, hopefully we'll have more clarification from the government to see how they're going to be addressing the adjustment of status process. But it is important for, regardless of that, of the recent policy announcement, that everyone who is going through this PERM process to get permanent status think about how they will actually be able to enter into the, or how they, which option they'll choose through the third step here, either I-485 adjustment or consular process. And then finally, we just want to be clear that when we talk about PERM, PERM in itself is not a visa. It is actually a process to get permanent status through a test of the labor market through the Department of Labor. So as I mentioned earlier, it is important. Oh, I'm sorry. This says, someone says there's no screen sharing. I'm so sorry about that. Let me make sure it's shared right now. I'm not sure why it's not shared. I will try it again. Thank you for letting me know that, Michelle. I did not know that the screen sharing was not happening. So let us go back to showing the screen. I won't go over the whole details of what I went before, but hopefully you are seeing the screen now. And I just want to show you the screen that I was referring to earlier. And just to let you know, we will have, or we will share the presentation recording as well as the slides. So you'll have that as well. But this is the slide I was talking about when we were talking about the PERM process itself. So let's go on to the next step, or next slide, where we talk about the different pathways of PERM. So there are actually 3 different options for applying through PERM, through the PERM process. We'll talk mainly about the standard PERM, which is standard PERM process, which is the vast majority of cases. Most people will have no choice but to go through PERM, through the standard PERM. But we'll also talk about other options which are very specific for certain people who qualify. So we'll talk about the Schedule A, pre-certified occupations. And the advantage to this is that if you do qualify for Schedule A, the Department of Labor has already determined that there is a worker shortage, so they do not require you to go through any recruitment. And in fact, you do not actually even need to go through the PERM, the Department of Labor certification process. In fact, you can file directly with the USCIS at the I-140 stage as opposed to the PERM stage. Then we also have the optional special recruitment PERM process, where, as the term implies, there is recruitment required. However, the recruitment is somewhat less than the standard PERM process, and the standard of review is also better than the standard PERM process. So optional special recruitment is limited to those who are college and university teachers. So let's get more into detail about these 2 sort of exceptions to the standard PERM process. So we'll talk about Schedule A. And so, as I mentioned, Schedule A does allow or does not require recruitment. So it can actually cut down on quite a bit of time in terms of processing through the USCIS and the Department of Labor. So no recruitment is required because the Department of Labor has already said that these particular occupations, we already know that there is a shortage, so we don't need you to go and test the market and do recruitment and advertising. So who does qualify, or who does qualify for Schedule A, or who can use them? Well, Schedule A is limited to, there's 2 types of Schedule A. So generally, Schedule A would apply to those who are sponsoring nurses and physical therapists. It could also apply for those who are sponsoring scientists or people who are in the sciences who have a lot of recognition for the work that they've done. And we'll talk a little more in detail about that. And then we have also employers, if you're sponsoring, which is pretty rare, but sponsoring certain artists or performers who have had been considered exceptional. This could also be Schedule A, could also be an option as well. So with Schedule A, as I did mention that we do not necessarily have to go through we do not need to go through the Department of Labor as far as getting a PERM certification, which does cut out nearly a year or two of time in the process. However, there is still a requirement of prevailing wage, meaning that the employer has to show and agree to pay the minimum of what the government says is the salary for that occupation. And then the employer does also still have to, even though there's not a recruitment requirement, it still has to notify its current workforce of the fact that it's applying for a Schedule A PERM application by posting a notice of filing. Okay, and then logistically, after that's done, then the employer submits their I-140 and also submits a particular form called ETA 9089, and submits that to the Department of Homeland Security, USCIS. Talking a little bit more about the shortage, about the Schedule A and who qualifies. As I mentioned, we have two different types of Schedule A employees or occupations. The first one, and probably the easiest one to prove, is Group 1. These are those who are licensed physical therapists and those who are professional nurses. So when we mean professional nurses, they usually have either a bachelor's or an associate's degree in nursing, can qualify for a state license or already have a state license and have also received a what's called a CGF&S certificate. This is from the Commission of Graduate Foreign Nurses, where they certify that that nurse has the necessary education to be a nurse. So it's important to also know that this is professional nurses, does not mean all types of nurses. So licensed practical nurses, certified nursing assistants, and anything that's not really a RN position would not qualify for Schedule A. Those occupations can still be sponsored through the standard process, but they cannot be considered Schedule A. But it is also important to note that nurse practitioners, who usually are master's degree nurses, also qualify for Schedule A as well. And they are also considered at a higher level in terms of the EB2, or a higher level in terms of the employment category, which means that they can potentially get their green cards faster than other non-nurses who are not nurse practitioners. The other category of Schedule A is Group 2, exceptional ability. So this would be any employee who is either working in science occupations or performing arts occupations. And this is rarely used, but it may be something that many people really haven't considered and could actually consider if the qualifications of the individual employee are rise to that level. So for an exceptional ability application, PERM application, the occupation has to be in the sciences, and that the employee themselves have to have demonstrated through various criteria that they have had recognition as international recognition as someone who is a leader in their field, whether that's in arts or in sciences. So it's important to evaluate and look at the CV or the background of the employee, and if they've done outstanding work that has been recognized in their professional community, this might be an option to consider. And the reason for doing that is, even though it is employer sponsored, so it's not something that they can do on their own in terms of applying for Schedule A, Group 2 exceptional ability. It does cut down on quite a bit of the processing time. You avoid having to go through the Department of Labor and waiting for that process to be completed. So how is Schedule A, again, different from the standard PERM? As we'll discuss, the recruitment is not required for Schedule A, whereas the standard PERM usually can have about 7 steps of recruitment. The standard PERM will require that the employer file through the Department of Labor in a online program called FLAG, whereas with Schedule A, the employer does not have to go through the Department of Labor. You would actually apply directly and go to the I-140 stage with the USCIS. There is sometimes a random or triggered audit that could be conducted and through the standard PERM, which would cause a delay in the application process itself. With Schedule A, there is very rarely an audit. The Department of Labor does not audit it, and very rarely, if ever, does the Department of Homeland Security ever audit a Schedule A application. Typical timeline, which is key here, as I mentioned, excuse me, is that the standard PERM can take currently over a year and a half after the employer has gone through the recruitment process and submitted the PERM application. It could still take another year and a half to get a decision from the Department of Labor. Whereas with Schedule A, you're applying directly to the Department of Homeland Security, and you can actually do premium processing, which means it can actually be decided within 15 business days. There is a prevailing wage requirement, however, for both the standard PERM and the Schedule A, as well as a notice of filing requirement, as I mentioned. So now let's very briefly talk about optional special recruitment for college, universities, and college and university teachers. So some of you on the call may be involved with that, or may be employed by, or be an employer, a university or college, or be employed by a university, college, or college. So this process was created many, many years ago to kind of carve out an exception or carve out a special process for university teachers, and basically to be eligible for that, for optional special recruitment. The employer has to be an accredited college or university. The position itself has to be a permanent position, not a temporary teaching position. It has to be permanent, so either it's going to be tenure or tenure track type of position. And the position, of course, has to have some teaching component to it. Now, it doesn't mean that it has to be 100% teaching. There can be research, there can be other job duties, but as long as there is some teaching requirement for that position, then it could qualify for optional special recruitment. The selection process is for the recruitment portion of it is that the employer has to show, the university has to show that they did have a competitive recruitment process. They did at least advertise in a national professional journal, and that's only one advertisement. It's not, and there's really no specific time frame. They can advertise for 1 week, 1 year, whatever time frame they would like for that. And then they also have to show that after they've done the recruitment, that they did have a specific selection committee that went through the applications, excuse me, and determined that the employee, the sponsored employee, was the best qualified for the position. In addition, we have timing requirements that are a little bit different than the standard PERM. So you can actually, you would need to, in order to use the selection process or this particular selection process, you would need to make sure that that process is completed before deciding to sponsor the university employee. The application for PERM, the ETA 9089, must be filed within 18 months of the offer of employment. So, for example, if the faculty was offered the employment today, May 28th, 2026, even though they may not have started actually teaching until the fall of 2026, the deadline to submit the PERM application is 18 months from today. And that's a hard deadline with no exceptions. Okay, well, let's move on now finally to the standard PERM, which really is, as I mentioned, the majority of PERM applications. And it's important that everyone know that this is an employer-sponsored application, so an employer has to agree to go through this process. It actually has to agree to pay any cost, including advertisement costs related to this process. And it has to agree to pay the minimum of the prevailing wage for the salary that the government determines to be the prevailing wage of the salary. So let's talk about the recruitment, because this is where there can be issues of potential for denial if the recruitment is not done in accordance with the Department of Labor requirements. Oftentimes, we will have clients come to us or employers come to us and say they want to go through this process. The employee has already been in the job for many, many years. So the job really isn't open as far as it being, advertised and available to the public. So they wonder, why do we have to go through this process? And unfortunately, it is a requirement because the government wants to know currently at this time, since you are now applying for permanent status for this employee, what does the market look like now? What does the employment market look like now? The government wants to be sure that potentially U.S. employees, U.S. citizens and permanent residents have an opportunity for this job. So you have to test the market by going through this advertisement campaign as set forth by the Department of Labor. And what I have on this slide is for professional positions. So there is a difference between professional positions and other types of positions. So professional position would be considered a position that typically requires a bachelor's degree or higher. So if your position requires at least a bachelor's degree, then you would need to go through the mandatory professional position recruitment. Any positions that are less than that, do not require a bachelor's degree, still has to go through a mandatory recruitment, but they do not need to do this +3 menu here that I mentioned. So basically for professional positions and non-professional positions, it's always required that there are 2 Sunday print ads, newspapers in your local area. So for us in the Dallas area, for example, our newspaper of general circulation, the largest newspaper in this area is the Dallas Morning News. So there's a requirement that someone who's going to be working in the Dallas area would need to make sure that the employer publishes 2 Sunday print ads. Of course, if you're in Minnesota, then you would use, the appropriate publication there. So it's important to determine which is the appropriate publication and make sure you have 2 Sunday print ads. In addition to that, there is a requirement that the state workforce agency also receive a posting of the job notice. So what that means is that the employer has to advertise with the state workforce agency, which most people know it as the Unemployment Commission. So in Texas, we have the Texas Workforce Commission, and most of that kind of relates to those who are unemployed and looking for jobs. And so this job order is placed with that agency so that those who are looking for positions can see that as an open position as well. In addition, we also have to always have an internal job posting, meaning that on the employer's work site, where you normally would post HR notices, things like that on an employee bulletin board, or if you have an electronic posting system, then you would need to post that job on that system for 10 consecutive business days. And then finally, you can also have a notice of filing. So if you have an electronic posting system, then you would need to do the internal job posting. But if you do not have that, or even if you do have that, you still would need to also file a notice of filing, which is a paper notice as well. Our firm would certainly help with preparing that notice of filing so that it is compliant and posted appropriately. Now, if you are, again, in a professional position being sponsored, then in addition to this always required column, you would have to look into this column to make sure that you are also selecting 3 other forms of recruitment that are being three other forms of recruitment. So these are all the options. There's about 9 options here. Most typical options that people will use, and least expensive options would be something like an employer's work website. If you have a jobs website that you keep as an employer, or your employer has that, then you post there. They might also post on a job search website like Indeed, or even the newspapers typically have their own corresponding website for job searches. So that could be another one. But other options would include like a trade or professional journal, a job fair, radio, television, placing the ad at a university, on-campus recruiting, any employee referral program if you have that, or another local, smaller newspaper in the area. You could do those. So the employer would choose those options and also post those as well. So I know we don't have time to get into all the specifics of it, but it's very important to know that the recruitment can be pretty broad, but there are choices in what you can do as far as the optional or the additional professional recruitment requirements. So another requirement for PERM where some employers could get into trouble, and then we say get in trouble meaning the case might not be approved if you are overly restrictive on your job description. So it's very important when you start the process that the job description is very clear in terms of the job requirements, the job duties, that sort of thing. But in particular, with the job requirements, the government does have its own database called ONET, where they have determined what are the usual requirements for a position. So for example, for an entry-level engineering position, the requirement, civil engineering position, the requirement would be bachelor's of science in civil engineering, as an example. But if the employer is now saying, oh no, I really want to require a master's level for this entry-level position, because the candidate, the employee, the foreign sponsored employee already has a master's degree, the government will say, why do you need that? That's overly restrictive, because we know a bachelor's is something that's normally required. So we have to be careful not to exceed what the government in its ONET database says is the minimum requirement. In addition, if you want to require experience, or there is an experience requirement, you have to make sure again that that experience requirement is not more than what is typical for a position like the one that you're offering or the employer is offering. So if the position normally the employer has accepted 2 years of experience, they can't now say, well, we want 5 years of experience in that position. You also want to make sure that you're not tailoring, or the employer is not tailoring the job to the skills of the beneficiary, which is the sponsored employee's resume. You don't want to say, well, this employee has all these different skills. We really like those skills. Maybe we don't really need them specifically for this job. Like if someone was coming in entry level, or maybe this employee didn't even have these skills until later. You have to be careful that, you're not doing that you are making sure that you are having not necessarily generic, but a job description that is typical for your job, but also for the industry as well. And then finally, foreign language. We often get employers that do like the fact that the employee has foreign language, and they might have some need for it, but not a whole lot of need for it. But they will say, we'll ask if, could we include that as a requirement? And while you can, you would have to prove that it is a true business necessity, which sometimes would mean proving that you have, a lot of documents in that foreign language. You have a lot of customers in that foreign language. So there's a higher level or high level of proof that's required in order for you to require that particular language as well. So 2 other areas that employers need to be careful about when applying for a PERM application. There is the layoff trap. And so this is kind of happening more as we're seeing more layoffs currently in the past year or so. So if an employer is going to sponsor an employee through the PERM process, and if they have had layoffs in the 6 months before applying for PERM, that can be an issue. It can cause delay. It can cause an audit in the process. So typically the ideal situation is that you should not, an employer should not file a PERM application within 6 months of having a layoff in the same occupation or a related occupation. So if you have an employee who is, again, use the engineering example, that's a civil engineer, and you have, excuse me, laid off civil engineers in the Dallas area with the same, qualifications and same position, then you would not be able to really file a PERM application, or it would not be advisable to file one unless you are willing to go ahead and not only do the recruitment, but also notify the laid off US workers that there's this open position and allow them to reapply for that. And so, it would be a lot more requirements there. So the best scenario in most cases would be not to apply until at least after 6 months of layoffs. Another area that's probably more common that can be an issue is that you need to make sure as an employer, or the employer needs to make sure that they are documenting any rejections of US citizen applicants who do apply for the position through the recruitment process. So as we talked about, there's very specific recruitment required. And if the employer has done that recruitment and is now receiving applications or resumes, you can't just let the resume sit there. You have to go through and treat the process just as you would for any recruitment process. If you're looking for someone to hire, you want to make sure that you identify each applicant, document your outreach to them. If you interview them, document what the results of the interview were. And also, if they are not a qualified applicant, you need to explain why they are not qualified, or have a report that shows why they're not qualified. So it's very important to be very detailed in that, and that's something that has to be done before the PERM application is filed. So then, and speaking of filing, let's talk about what happens during the filing and what the Department of Labor does. So the filing itself is through an online system called FLAG. And basically it is the form ETA 9089. All the information is completed about the employer, about the recruitment that was done, about the beneficiary or the employee's experience, their degree. So both the employer and the employee sign off on the application and then file it electronically. Once it's filed, now it goes into that process of 6 to 18 months. I would say right now it's more 18 months. In the past, we saw as quick as 6 months, but currently we're seeing more of an 18-month time frame. You also have to, in itself, before filing the ETA 9089 through FLAG, you also have to have obtained a prevailing wage determination from the Department of Labor, where they say this is the minimum salary that must be paid to this position. So that must be also approved before filing. And then even after filing, there is important, and even after approval or certification, it's important that the employer keep documentation of the recruitment that was done, the recruitment report, copies of the recruitment ad, any documents that are required to be generated during the PERM process must be kept for at least 5 years by the employer, because the Department of Labor can come back to audit within 5 years of the PERM certification. So when we talk about audit, they can do an audit before they approve the PERM, or they can do an audit after approval of the PERM. I will say, in my experience, I've never seen an audit done after the approval of a PERM. However, we have seen audits happen before a perm is approved. And if that does happen, typically an audit does cause at least another 6-month delay in terms of processing of the perm or certification of the perm. Now, I think about 5% or so of perm applications do receive an audit request. And some of it is very random. We don't know if there's any particular reason for it. It could be just a random audit, system that they have. But we do know that there are certain triggers in perm applications that will cause an audit. So for example, if the beneficiary, the employee, has been employed by the employer in that same role for many, many years, and if you have used some of their experience gained by the employer in order to qualify the beneficiary, that might cause an audit. If it looks like the job requirements seem to be tailored to the employee's background, again, that can require an audit. So that's why we want to make sure we don't do those things. If there was a layoff, that could cause an audit as well. And then if there's that foreign language requirement, that almost 100% of the time will trigger an audit. So that's why you have to make sure you have all the proof of the business necessity of that foreign language requirement. And then finally, another trigger of the audit is if the employee is also a part owner of the company that is sponsoring, or if they're related to the owner in terms of maybe being a son, a daughter, a parent, that there's certain family relationships. If you have that family relationship to the owner, it could also cause an audit. Now, having an audit and having these things that happen doesn't necessarily mean that the perm will not be certified. If you can respond and provide proof for any of those issues that the government identifies, then it can still be approved. But it will usually cause a delay in the process. So from the employee's perspective, let's talk a little bit about what an employee needs to know as they're going through this PERM process, what you can and cannot control during the PERM process. First of all, we always want to let the foreign national employee know that this, again, is the PERM. The PERM is the employer's application. So you do not, well, I'm sorry, this is incorrect. You do sign it, but you cannot direct the strategy. You cannot be involved in the recruitment. You cannot be involved in looking at, applicants and determining whether they're qualified. Any of that recruitment process has to be controlled solely by the employer with no employee involvement. So that's number one. You should also know as an employee that the priority date is important. Priority date is established by the date that the PERM application is filed, the ETA 9089 is filed. Then, of course, it also is determined by the education requirements of the PERM application. So, for example, if the PERM application requires a master's degree or a bachelor's plus 5 years of experience degree, plus 5 years of experience, then you're going to be in the EB2 category, which could be faster than an EB3 category, which is a category that only requires a bachelor's degree or less for that position. So it's important to identify the education requirements appropriately, correctly, but also consider what that would mean in terms of priority date, because priority date does determine or help determine how quickly you will ultimately get the green card. You also need to know, as far as the PERM application is concerned, if you have gained a lot of the experience that you have with the employer to qualify for the job, generally that experience cannot be counted towards the requirements for the job. So for example, if the employer says we need 5 years of this specific type of experience, well, of course, you as the employee has to have that experience. However, if you gain that experience by working for the employer, then that your experience can't count towards that 5-year experience requirement, which means that you are not qualified for the position. So we have to be very careful when we're defining the job description. We have to be very careful that the employee does meet the qualifications and that we don't disqualify the employee because our experience requirements are too high or too high. So outside of that PERM requirement, after the PERM is approved and you're in the rest of the process, oftentimes employees want to know about what happens if I change jobs. So if you change jobs after the final step, the adjustment of status application is filed, then you can if you change jobs 180 days after the adjustment of status application is filed, then in most cases you can continue with your green card process and get final approval as long as the new job is same or similar occupation as the PERM job that was sponsored. Now, if your job is changing within the employer before the I-485 or before or even during the PERM or at any time before the I-485, then we have to look at, is this job very different from the PERM job? Because if it's very different, then we may need to actually do a new PERM because the PERM is very, very specific to a job. You can't say, well, now I am a civil engineer, but now I'm going to be a CEO. Okay, not doing any engineering work. I'm just managing the company in itself. So if that's the case, and you still have not gotten into the adjustment of status phase, or even if you are in the adjustment of status phase, that job might be too different from the PERM job. So we have to look at, any changes that are happening or potentially happening before they actually happen to ensure that the PERM is still valid or to determine if we have to change strategy. And then finally, we talk about risk management. So when we get denials or when companies are denied the PERM application, it's usually because of things like the recruitment wasn't done appropriately. So you want to be sure as you're doing the recruitment, you want to make sure that the ads are placed in the right publications. You do not miss any posting deadlines. You document each step of the way. Make sure you have copies of all of the recruitment, all those things. You just really have to make sure all that paperwork is there. The second denial ground, which I've talked about before, is making sure that your job requirements are not excessive. They do not exceed what the ONET determines as normal, unless you can prove it, unless you can have documented business necessity that says, hey, I know this is normal for most people in the industry, but my job has these special needs because of ABC, and you can prove those things. Another form of rejection is failure to consider U.S. applicants. So in particular, if there's an audit, the government will want to see if there were any applicants for the position. The government will want to see their resume. So you want to make sure you keep the resumes of those applicants. They will want to see what you did in terms of interviewing them, your interview documents, why they were not considered. So you have to make sure that you can ultimately justify why a U.S. citizen or green card holder application was not accepted. Now, when I say that, I don't mean that you had to have the employer has to have hired that person. What it means is that that if a person, according to the Department of Labor, seems to have qualified in every way, and they do not agree with you that that person is not qualified, that means that they'll deny the PERM, but it doesn't mean that you should have hired that person. What that means is that they believe you should not have applied for PERM because you were not able to show that the market did not have qualified workers. And then the last area that we see denials is if you have prevailing wage violation, or we can see denials as we have prevailing wage violation. So if you're offering a wage or do not agree, or if you do, if you're offering a wage below the prevailing wage, or if any of your recruitment documents showed a wage that was less than the prevailing wage. So oftentimes what we do is, first of all, we want to have that prevailing wage determination. And if we're going to advertise our salary, in some states, you actually have to advertise the salary. Like, for example, in California, you have to advertise the salary. In other states, you don't have to. But in any event, if you are advertising that salary, you have to be sure that salary listed, even if it's a range, has to be above the prevailing wage and not even a penny less. So you have to be sure you're making your advertisement very clear in terms of the wage meeting the prevailing wage requirement. So that being said, I do want to leave a few minutes. I know we covered a lot and it's a pretty complex area, but if there are any questions, please feel free to enter them now into our Q&A chat box. Again, I do want to remind everyone, if you're going to ask a question in the chat, please do keep it general so that you do not reveal any personal or confidential information about yourself. So I will look at this chat. I don't see any questions so far. So I do want to invite you, and even if it's a question that may not necessarily be related to this information, and I see right now we do get a question here that's not related to this, but I will briefly answer. There's a question about the R1 visa. So an R1 visa is for a religious worker, and kind of related to this in a way. If you have an R1 visa and you want to get permanent status, PERM applications or a PERM process is a way that someone can qualify for permanent status. When we get religious workers, we have to look at exactly what type of worker they are, what type of work that they do. We might be able to go through the religious worker green card route, which is a totally separate type of application. But oftentimes we can go through the PERM route as well. And we have done that as well. So if you have an R1 and you have the potential for an employer to sponsor you for a PERM process, that is certainly doable depending on, and we will just have to make sure that, it qualifies through all of the PERM requirements. Another question is, do the physicians qualify for exceptional PERM pathway? Yes, you can certainly do that as scientists or being in the field of science as well. So physicians can, if you can show, it's not necessarily an EB1 level of documentation, but it does require quite a few it does have quite a few criteria that shows that you have that international recognition, whether it's through publications, peer review work that you do, different things, but the level of review is not as high as an EB1A, so it's more a greater likelihood of getting approved through a PERM Schedule A Group 1 pathway. So that's something that physicians and those who are in sciences should certainly consider if they've done quite a bit of professional work that's been recognized. For an L1A, the next question is for an L1A for a new office transition to permanent status is PERM the only route, or there's an alternative? So if it's new office, meaning that, you've just established an office, you got an L1 visa. And so after a year of having the L1A, then you have to, you extend, you can extend for another 3 years and then another 3 years after that. So if you're wanting to go to permanent status, PERM is a route. But actually it's not the only route. You can also consider the EB1, EB1C route, which is very similar in criteria as an L1A. But it does require that the employer be established for at least 1 year before you can qualify. So I would definitely look at that particular employee's position outside the US before they came on an L1A and their current position, and look at whether or not an EB1C might be a better option, where that does not require all of the recruitment and different Department of Labor overview, oversight, or anything like that. You can actually apply directly with the Department of Homeland Security and really bypass a lot of this. And it's a much quicker process through the EB1C route. Another question is, can someone who applied for the green card visit the USA? So that's kind of, yes, I mean, it's possible. It really depends. If you're talking about a visitor visa, if there has been a green card application, it will usually be a negative factor for the green card, I mean, for the visitor visa. But if you can show other positive factors, like you have a strong job in your home country, strong financial circumstances there, strong family relationships, things like that, and you're very clear that you will be returning back after your stay, then it's very possible. But getting visitor visas is always, or if you already have a visitor visa, there's no, you can still use that. If it's still valid, you can still use that even if you've applied for a green card. But if you're trying to get a visitor visa, you will have to reveal that you are in the green card process, and that will be something to be considered, but it doesn't necessarily mean you have to be denied the visitor visa. Another question is, what if regular perm is already filed? Can we still request the employer to pursue the exceptional perm pathway based on research and peer review and conference presentations? And yes, and I'm sorry, and does the employer, attorney and employer have to pursue has to pursue? Yes. Well, to answer the last question, yes, it has to be still employer. It's not a self-petitioning process, so you'd still have to have the employer apply. And the way they apply is they have to still get a prevailing wage determination. And they have to, after getting the prevailing wage determination, gather all the documentation and submit it through the I-140 process. There is no prohibition, as far as I know, with respect to having, if you've already filed a regular perm, that you cannot do the exceptional Schedule A perm. Excuse me. And so another question is, so can an O1A visa qualify for a green card after 1 year? So, excuse me, for an O1A, there's not any timeline of waiting. If you have an O1A and you otherwise qualify for the green card, whether it's through another EB1 or going through a PERM or whatever process that you qualify for, you can certainly do that. There's nothing that says you have to wait any specific time frame after having an O1A visa to apply. Okay. I don't see any other questions here. That being said, if there are no other questions, I want to thank you all for attending today. I do want to remind you that immigration law is changing all the time. But if you do, and so if you do need immigration assistance, feel free to reach out to us, contact us by either calling, emailing, or going online to schedule a consultation with one of our attorneys so that we can specifically guide you through your process or advise you appropriately. Thank you again. Let me just check one more and see if there's anything else. Oh, thank you all. And yes, we do have a recording, so we will be sending that out to you as well. Thank you all and have a great day.